Today, we're going to discuss how those changes have affected the life sciences and the computer arts. The "are we there yet" question, the short answer is no, we are not. But the reason for that is because the law in this area is quite dynamic. We've got updates coming as recently as this year. And so this webinar is an attempt to keep ourselves updated on the many considerations and case law and other practice notes that we as practitioners should be aware of in the area of 35 U.S.C. Section 101. Whoops. So today I'll be speaking with my partner at the Oblon firm, Dr. Marina Miller. She's a partner in our chemical prosecution group. As you can see, her education is quite formidable. She's got a background in physics and molecular biology and biochemistry, and she works in a wide array of technological areas within the life sciences and the chemical arts. My name is Anna Lloyd. I am a partner at the firm's electrical patent prosecution group. And so together we hope to cover the field, so to speak, to discuss both the life sciences on Marina's end and the computer technologies on my end, and to determine what the most up-to-date considerations and practice notes are as far as patent eligibility. So to start, Marina, can you tell us a little bit about what the legal issues are for as far as patent eligibility is concerned?
Sure. Good morning, everyone, and thank you for joining us today. And again, my name is Marina Miller. And let's start with what is patentable in the United States under U.S. law. 35 U.S.C. Section 101 says, whoever invents or discovers a new and useful process, machine, manufacture, or composition of matter, or any improvement thereof, may obtain patent. However, Supreme Court has identified three fundamental principles that are not patent eligible, judicially created exceptions: law of nature, natural phenomena, abstract idea. Supreme Court repeatedly explained that abstract idea and law of nature are not patentable, in part because it would preempt the use of ideas and a law of nature in all fields. Next slide, please. Anna? It's important to remember that the claim is the name of the game. That means that it's important to recognize that many Section 101 rejections are a result of how the claims are constructed. In many cases, the claims reflect a failure to determine what the invention is. Therefore, many patent-eligible disputes arise because of lack of precision in the claims and failure to identify the invention and explain how it has been achieved. Therefore, the key to success, quality claims. It's important to identify what the invention is and how you do it. What others, for example, didn't do, that there is no preemption of natural law and abstract idea. The recent cases emphasize the importance of proper claiming. It's possible, for example, to have patent-eligible invention, but patent-ineligible claims. Next slide, please. Over the past few years, the U.S. courts, led by U.S. Supreme Court, have taken an active role in reshaping the legal concept of patent-eligible subject matter. Anna, next slide, please. In 2012, Supreme Court announced that methods of diagnosing a disease are ineligible for patenting under its decision in Meyer v. Prometheus. The reason was that measuring the concentration of a biomarker in diagnosing a patient as either overdose or underdose is nothing more than making a decision based on natural law. You see a simplified version of the claim at issue in this case. It's a method of optimizing treatment comprising administering a drug, determining the level of metabolite in the subject, and so-called wearing clause, which says when level is X, need more drug, level is Y, need less drug. Supreme Court determined that the claims do not add enough to natural law to be patent eligible. Administering and determining steps are routine, known, and highly general. Wearing step merely states law of nature, what occurs naturally in the body. The Supreme Court stated that simply appending conventional steps specified high level of generality to judicial exception cannot make judicial exception patentable. The question before us is whether the claims do significantly more than simply describing these natural laws. Problem with mine was that wearing clause did not require any subsequent action and merely told the doctor to consider the relationship. Perhaps a very different result would have been reached if metabolite or its impact on the body had not been known, or additional unconventional steps or combination of steps or additional limitations were recited in the claim. Anna, would you please tell us about the important Supreme Court case in abstract idea field in computer-related inventions?
Absolutely. So after 2 years after the Supreme Court issued Mayo, it came back to the question of subject matter eligibility, but this time in the computer arts. And that case was Alice, which came out in 2014. And in Alice, the claims were directed to a method of exchanging financial obligations using a computer. The crux of the invention and the focus of the disclosure in Alice was the financial part of the invention, and then the computer element was relatively generic. And so the Supreme Court reapplied essentially the same framework as they did in Mayo, and they said that, look, the financial portion of the claim is essentially a patent ineligible abstract idea. And because the computer implementation in Alice was quite generic, the Supreme Court found that the claims did not recite significantly more than just an instruction to apply that abstract idea to some sort of unspecified generic computer. So the claims in Alice were also found to be patent ineligible for failing to recite this significantly more something else, essentially. Alice also gave us some examples of what the court thought would be abstract ideas. So this was fundamental economic practices, certain methods of organizing human activity, an idea, or mathematical relationships or formulas. You'll notice that many of these categories are either incredibly broad or just difficult to pin down. And the courts and the entire patent community, I think, has been struggling to come up with any sort of consistent implementation of what falls into these categories and what doesn't. But the one-two punch of Mayo and Alice created this framework of what we've been using to determine whether claims are patent eligible or not. And so the two-part test was born. The two-part test first asks whether claims are directed to a patent ineligible concept. And we highlighted the words directed to here because, as we'll see later in our discussion, this is a difficult phrase also to pin down. Directed to is not reciting. It's something else. But in general, the question is whether the entirety of the claim embodies some sort of patent ineligible concept, such as a law of nature or an abstract idea. If the answer is yes, then the second part of the two-part test asks whether the claim elements considered individually or as an ordered combination transform the nature of the claim into a patent eligible application. And so this is where this significantly more language comes in. The question in the second part of the test is whether the claims do significantly more than whatever that judicial exception was, the natural law or the abstract idea. Marina, could you start us in discussing some recent case law as far as how the Mayo-Alice framework was applied in the life sciences?
Yes, sure. First of all, I would like to mention also important Supreme Court case, Associate of Molecular Pathology v. Myriad Genetics of 2013, where the court determined that a nature-based product without new characteristic was not patent eligible. The court focused on differences of the claimed product and its natural counterpart, markedly different characteristics, if you will, as U.S. Patent Office used buzzword, from any found in nature. In this case, the claims focused on genetic information, and there was no alteration in isolated genomic DNA compared to natural DNA, and therefore it was found to be patent ineligible. However, cDNA, which has different sequence from natural genomic DNA, was patent eligible. This case also important because the court also signaled that the application of natural law or product may be patent eligible. There are many lower court decisions post-Meyer, Alice, and Myriad in diagnostic methods and abstract idea fields that further shaped and clarified to some extent what is and is not patent eligible under Section 101. Next slide, please. The eligibility analysis of product and process claims is different. For example, product claims reciting natural products. Courts have asked one way or another whether the composition of product has some meaningful differences from its natural counterpart. For process claims reciting, abstract idea or law of nature, courts have asked again one way or another whether the idea or law recited in the claim is applied in any meaningful way. Next slide, please. Ariosa v. Sequinome 2015 case is the first case in which application test was used to analyze the subject matter eligibility of a process claim simply because it recited natural product or law. The Ariosa Federal Circuit found the claims to be patent ineligible. And again, I would like to stress that it's important to remember that is the claim that is evaluated for patent eligibility, not what was invented, which may be different. In Sequinome, the invention was discovery of the fetal DNA could be found in maternal bloodstream in relatively high concentration. Most of the claims were not directed to a diagnostic technique, but rather to a method of detecting fetal DNA in mother's bloodstream. And you see example of simplified claim 1 on your screen. The claims that directed to diagnostic technique were not separately argued and were incorrectly characterized in Sequinome opening brief. Claim 1 and other 24, 25 independent claims under Step 1 were found to be directed to natural phenomena or product. First of all, the court said that DNA occurred in mother's bloodstream naturally. The method began and ended with naturally occurring fetal DNA, and none of the genetic information encoded in the fetal DNA was altered in the process. And under Step 2, only conventional steps were recited in the claim. Therefore, claims similar to Claim 1 were found to be patent ineligible. However, the Federal Circuit did not consider how is it known to amplify if the presence of extracellular fetal DNA in the sample was not known. This is quite different from the situation in Meyer, where the existence of metabolite and its impact on the body were well known. In this case, Sequinome brief lumped Claim 21 together with other independent claim and characterized all of the independent claim as requiring the same steps as you see in Claim 1. However, Claim 21 included additional step of providing a diagnosis based on the presence or quality or quantity of fetal DNA. This claim required further manipulation in addition to merely detecting fetal DNA. Simply detection is not enough. And this mistake cost Sequinome a patent. Claim 21 does not claim nucleic acid or method of amplifying it. It claims the use, application under myriad of nucleic acid for paternal diagnosis. Under Step 2 also, Claim 21 contains two novel steps, amplifying and determining the quantity or quality of DNA. Taken together, the steps do not preempt all users of fetal DNA, only diagnostic users. And under myriad, Claim 21 should be patent eligible. Takeaway from Ariosa, I would like to stress again, proper claim drafting is essential in diagnostic field, and it's necessary to separately analyze and argue each claim. The initial reaction to this decision was that the broad diagnostic claims are not patent eligible. However, there is a light at the end of the tunnel in view of the later court decision. For example, in 2020 decision by Federal Circuit Illumina v. Ariosa, the court distinguished the method of preparation for performing diagnostic application of natural law from the diagnostic itself, which would not be patent eligible. You see an example of the long claim at issue in this case. I'm not going to read it. It just you could take a look at this later at your own time. It includes multiple steps, and it's a method for preparation of DNA fraction. The question in this case was whether the claims at issue were directed to natural phenomena or to specific application of the natural phenomena. Next slide, please. The patent at issue acknowledged the natural phenomena of cell-free fetal DNA in maternal bloodstream, but identify a problem that detection and separation was difficult because the small amount of fetal DNA in maternal bloodstream, and provided a specific solution based on the discovery of the difference in sizes between maternal and fetal DNA. And that discovery formed the basis for claimed invention, a method of preparing a fraction of cell-free DNA, which is enriched in fetal DNA. The claims are not directed to natural phenomena as in Ariosa 2015 case, but instead include physical process steps that result in DNA fraction that is different from naturally occurring fraction in mother's bloodstream. And contrasting with Ariosa, where the court said that the method began and ended with naturally occurring fetal DNA. In this case of Illumina 2020, the claims were found to be patent eligible. Next slide, please. The case is a good news for us. It expands the potential of patent eligibility for natural phenomena in product under Section 101. It suggests that the claim may be related to natural phenomena, but still be patent eligible if it does not claim the phenomena itself. In this case, also under Step 2, the claims were found to add significantly more. The court said that conventional technology can be used in unconventional way that could make claim patent eligible. Next slide, please. Another interesting case is Ex parte Li by Board of Appeal of USPTO of 2019. It patents for diagnostic methods which natural phenomena the patent claim is directed to under ALICE Step 1 could have significant impact for the analysis under ALICE Step 2. Simplified Claim 1 is presented on your screen, and it's a method of determining a risk of a disease in a human subject, and it's a very long claim. I just present here simplified Claim 1 with a few important steps. Collecting cells from buccal area of a subject, extracting RNA, producing DNA, and measuring the level of specific DNA molecules. Ex parte Lee and Ariosa 2015 share some similarities. They apply known tests to a new area of body, maternal plasma and buccal membrane. However, the decision ex parte Lee was different. The claims were patent eligible. This is because the natural phenomena determined by the examiner in ex parte Lee was the correlation between gene expression and risk of the disease. An application was directed to this natural correlation rather than to the presence of the sequences as in Ariosa. The board accepted that the claims are to, at some level, relate to this correlation of gene expression and disease under step 1, but disagree with examiner's analysis under step 2, that the claim did not contain inventive concept. Next slide, please. The steps in this claim, the swabbing and measuring RNA or cDNA levels from buccal membrane rather than in the colon cells, are not routine and conventional. The court said that just because a prior art describes extraction of DNA from mouse swabs, it doesn't make it common and routine. The court cited another case by Federal Circuit of 2018, Beckmeyer case, where the court clarified the prong well understood, routine and conventional, that the examiner has to provide strong evidence of the well understood, routine and conventional techniques used in the claim, because very often examiner just find one piece of prior art and reject the claims under step 2. The court in Beckmeyer said that whether a particular technology is well understood, routine and conventional, goes beyond what is simply known in prior art. The mere fact that something is disclosed in piece of prior art does not mean it was well understood, routine and conventional. Next slide, please. This case tells us that in patents for diagnostic method, which natural phenomena the patent is directed to may be just as important as whether it's directed to a natural phenomena at all. Board decision signals or suggests that applying non-diagnostic tests to new areas of body could be patent eligible. And applicants should not only argue whether their patent is directed to natural phenomena, but also to which natural phenomena it's directed to. Next slide, please. What about combination of diagnosing and treating in one claim? Are those claims still patent eligible? One court said no. Diagnosing a disease followed by selective treatment of the disease based on diagnosis is patent ineligible. The decision signals in this case of INO therapeutics signals that medical treatment that relate to human physiology may be patent ineligible. In patented issue, natural phenomena was that INO gas had been used for treating infants with respiratory failure, but particular population of the patients, this treatment caused adverse event, and which was natural phenomena. As drafted, Claim 1, and you see it on your screen, is directed to a method of treatment patient who are candidates for specific treatment, inhaled nitric oxide treatment. The claim includes identifying particular population of patients in non-LVD, and it's a left ventricular dysfunction in LVD patient, administering specific dose of treatment to non-LVD patient, and excluding LVD patient from treatment. Basically, the claim says instruct physician identify LVD patient, instruct physician to administer the treatment to non-LVD patient, which was known in all steps, and now do nothing for LVD patient, which was new, and let the natural process take place in body of the LVD patient. an exclusionary step E, which you see on your screen, merely restates the law of nature, and it's nothing to it. The treatment step, although present, step D in the claim, was known, and the court said that it is not the focus of the claimed invention. The focus of the invention is on screening for particular adverse condition, and then requires the treatment be withheld. The method does not include any new treatment of LVD patient, for example, by a different drug or titrating the NRO dosage. But what if the claim tells the doctors to administer, for example, low dose or different drug? Would the result would this claim pass Section 101? Based on the additional case law which is available to us now, possibly yes. In this case of INO therapeutics, inventors observed the natural phenomena, but the claim stopped short of improved treatment method of LVD patient. Therefore, the claim was found to be patent ineligible. Next slide, please. In different case, Wanda, the decision was different. And I forgot to mention in the previous case, would you please go to the previous slide? The majority, according to the dissent, improperly separated the claim into all the new steps. Steps of natural phenomena and steps well understood, routine, and conventional, but ignore the requirement that a claimed invention is considered as a whole. And as a whole, according to the dissent, the claim is not directed to natural law. First of all, it's conducted by a human, and also the inventors observed a natural phenomena and then developed a treatment method that took advantage of the observation to avoid adverse effect. Now we will go to next case, next slide, please. In Wanda, the decision was different. The claims were found patent eligible, not directed to natural phenomena under two-step analysis, Meyer-Ellis. The claim in Wanda didn't simply instruct the doctors to stop treatment patient with the drug based on the diagnosis. The inventors in Wanda discovered a set of natural relationships, and the claims relied on the natural relationship to improve and to provide treatment for all patients for schizophrenia. You see the claim simplify again on your screen. The claim directed to improve treatment of specific disease with specific drug in a specific patient population in a specific way to achieve specific result. The claims in Wanda are different from Maya and INO therapeutics. They rely on natural phenomena to improve treatment of all patients for schizophrenia. It's a specific new way to provide therapeutic benefit to all patients suffering from schizophrenia. Next slide, please. The Federal Circuit emphasized that new and improved method of treatment in personalized medicine remain patent eligible. The focus of the invention is on treatment, as also confirming in two cases which you see on your screen. As in Wanda, in these cases, the claims actually require to administer the dosage form. The claim used a particular dose of a substance to obtain specific benefit by altering the subject natural state. In INO therapeutic case, as on the previous slide, the invention is not focused on changing the physical and physiological state of the patient to treat the disease. The claim invention is focused on screening for natural law as determined by the court. Next slide, please. Here you see a few examples of some eligible subject matter in chemical life sciences, cDNA, nature-based products with new characteristics, method, diagnostic method, if they include technical improvement, new way of detecting natural law, unconventional combination of known elements, also practical application of natural law. Method of treatment where when applying a natural law, if there are new specific treatment and provide therapeutic benefit to all patients suffering from the disease. And now, Anna, would you please maybe tell us about recent cases in computer-related field where the court discussed abstract idea, judicial exception, and explain what is or is not, perhaps is more clear what is abstract idea in the claims.
Absolutely. So as the case law was developing in the life science field, of course, in the computer technologies field, it was developing in parallel as well. And the Federal Circuit has been issuing decisions in this area as well. However, the clarity or consistency of applying Section 101 remain elusive as far as the abstract idea of judicial exception is concerned. I put this quote here from a recent Federal Circuit case where the Federal Circuit themselves admit that courts might be tempted to opt for a coin toss rather than a reasoned analysis when faced with a Section 101 challenge. And as noted in the same quote here, the Federal Circuit realizes that the parties are entitled to something more. However, the jurisprudence as of right now is not entirely consistent or clear as to whether particular claims fall inside or outside of the patent eligibility umbrella. So software and financial technologies in general have been hit quite hard by Section 101 challenges. But as we'll see later in our discussion, especially with respect to the American Axle case, no technology is safe, especially because the idea of an abstract idea is so broad that sometimes abstract ideas are found in quite physical inventions. Initially, I'd like to discuss the McCrow case. This was a Federal Circuit case that set up some good arguments that applicants can make and good approaches for applicants to structure their claims in a way that would be found patent eligible. In McCrow, the claims were directed to a computer implemented algorithm that would automate what was previously done by human animators. So prior to this invention, humans would synchronize lip movements of animated images with the audio of what those images were supposed to be saying. And, they used subjective criteria, just as humans tend to do. Whereas the invention in McCrow created these limited rules that would automate essentially that synchronization process, but they did so by using rules that human animators were not using. So this was something specific to the algorithm, and the court in McCrow made a note of this and stated that because these were very limited rules and they did not merely automate what was previously done by humans, but were instead an entirely different algorithm. This swayed the court in the direction of patent eligibility. And so this provides for applicants, because computer-related inventions often tend to automate human tasks, this provided a good clue to patent holders and applicants as to how to argue for patent eligibility, which is to say that the claimed invention is very limited to whichever rules are found in the algorithm, and that the invention is not how humans do it, essentially. So that was McCrow. I did previously just mention American Axle, and this was a case that came out of the Federal Circuit last year. And this was quite surprising because the claim was directed to a method for manufacturing a shaft assembly of a driveline system in order to attenuate certain vibrations that would be transmitted through the shaft assembly. So as you can see, this is a very mechanical invention. As an electrical engineer, I only have a vague idea as to what a shaft assembly or a driveline system are. And yet, this claim was found patent ineligible. And the reason that the majority opinion at the Federal Circuit reached that conclusion is that they of course realized that the specification in the case did provide the technical problem being solved, and that was the need to dampen certain vibrations simultaneously. The problem the majority found was that there was no how. And this is something that Marina mentioned in her earlier slides when she said the claim is the name of the game. The best way to ensure that claims are found patent eligible is to claim the how. And in this case, the majority found that the patent claims do not describe a specific method for applying Hooke's law. So Hooke's law is physics. Essentially, it's a physical law that relates to vibrations and would surely be implicated in an invention such as this one. However, the court found that there was nothing above and beyond what was known as Hooke's law as far as creating the solution that was claimed. And so the majority found the claim patent ineligible because it found that the claim would merely require an application of Hooke's law without anything else. So I keep saying the majority opinion because there was a dissent, and Judge Moore makes some interesting points in her dissent. She was quite strongly worded, and her points were that Hooke's law was not even claimed in the claim in American Axle. And so her point is that the use of an unclaimed natural law in the performance of what it was clearly an industrial process was not enough to find the claims directed to that natural law. So she disagreed with the majority in their application of the first step of the Mayo-Alice framework. If it were up to her, she would find that the claims were not even directed to a natural law. And the reason she reached this different conclusion is that she points out that the natural laws underpin pretty much all inventions, most inventions. And so her approach was that this would be a slippery slope, and that the unstated natural laws that lurk in the operation of every claimed invention would essentially make every patent application open to a Section 101 challenge. And so that was something that was, the majority opinion was surprising, and Judge Moore's dissent is worth noting in this case. So after American Axle, I want to bring attention to an even more recent case, which is TechSec, which came out of the Federal Circuit this year. This was more of a return for the Federal Circuit to their usual application of Section 101. And in this case, it was a claimed method of providing multi-level multimedia security in a data network. So clearly more computer related. And these claims were found patent eligible. And the reason we're highlighting this case today is that it provides good reminders as to how to structure the entirety of the patent application in order to support patent eligibility. So in TechSec, the Federal Circuit looked for the problem as it was defined in the specification, and then it looked as to how the claims provide a solution to that problem. And so the Federal Circuit finds that the problem was specifically arising in the realm of computer networks, of course, because it's based on data security. And then it found that the specific improvement was to the computer capability itself or the network functionality. And so both of those findings were in favor of patent eligibility. Okay, so these are just some quotes from the opinion in TechSec. And what was interesting was the Federal Circuit actually quoted from the background section of the disclosure because they found that is where the patent really clarifies that the focus of the claimed invention is on improving the data network. And so this was part of this led to the Federal Circuit to find that that there was an inventive concept and that it was technical and that it improved the computer functionality. So the reason for talking about TechSec, I think, is that it provides a good example of how to structure one's patent application such that it tells a story. So in TechSec, the Federal Circuit just followed the story. It followed the breadcrumbs that were started out in the background section, where the problem is discussed in technical terms, and then the specification goes on to continue to focus on the technical aspects of the invention, and then everything is tied together with the claims. As Marina mentioned, the claim is the name of the game, that the claims are what is found eligible or ineligible, but they could lean heavily, how the claims are interpreted could lean heavily on how the problem and the solution are characterized in the specification. So Marina and I have just gone over a lot of case law, and the PTO has had to keep up with this body of case law as well. So Marina, maybe you could tell us a little bit about how they've been dealing with all of this changing landscape.
Thank you, Anna. As we discussed, there are many cases of the Supreme Court and lower court related to judicial exception and what is and is not patent eligible. And USPTO has responded to this body of law with ongoing stream of revised, pre-revised, non-final, interim guidelines and memos. Guidelines are used to train examiners in the attempt to be consistent with the court decision and also to provide consistency between examination by different examiners and even different art unions. And the examiners are being encouraged to reject claims based on the guidelines. And diagnostic claims and abstract idea-related claims are routinely rejected. However, the Supreme Court and lower courts carefully and explicitly limited the scope of their decision to specific facts and warned about a broad interpretation of eligible subject matter in the cases at hand. However, the USPTO hasn't been so limiting and reasonable. And it's important to remember, however, that guidelines do not have the force of law. Guidelines are neither statute nor judicial doctrine. They are simply examination policy. And the courts and PTO and the courts are not bound by examination policy. For example, in the recent case of 2019 by Federal Circuit, Cleveland Clinic 2, the court says, while we greatly respect the USPTO's exercise on all matters related to patentability, including patent eligibility, we are not bound by its guidance. And the court declined in this case to follow the USPTO example 29 related to diagnostic and treatment methods. The Federal Circuit stated that determined that its president and not the USPTO guidance must control. And pre-2019 guidelines are based on Meyer-Ellis framework. Examiner in step 1 has to determine is the claim directed to a process, machine, manufacture, composition of matter. If you remember first slide, 35 U.S.C. section 101 stated that eligible subjects for patenting the process, machine, manufacture, composition of matter, or their improvement. If the answer to step 1 is yes, examiner has to go to step 2. It includes 2 parts. Step 2A, examining step 2A, examiner has to determine are the claims directed to a judicial exception. And if yes, then examiner has to go to step 2B and answer the question, do other limitations in the claim amount to significantly more than judicial exception? That's what the guideline steps for examination pre-2019. However, in 2019, the guidance by the USPTO became a little different, and Anna will explain what the differences are in the current examination guidance.
Okay, so on the left-hand side of this slide, we see what Marina just went over. Essentially, we've got step 1, step 2A, and step 2B in the same order as she explained. So the left-hand side shows us the pre-2019 flow of the analysis that the examiners were provided for determining patent eligibility. Now, in 2019, there was a change made to specifically step 2A, and that's the blown up portion on the right-hand side. And so step 2A is the question of whether the claim is directed to the law of nature, natural phenomenon, or abstract idea. And this comes back to what I mentioned earlier, where these words directed to are difficult to pin down. And so the PTO provided additional guidance for examiners to figure out what that means and to figure out whether any given claims are really directed to the judicial exception. So the new guidance provides 2 prongs. Now, there are 2 different questions that the examiners answer as part of determining how step 2A is answered. Prong 1 asks whether the claim recites the abstract idea, law of nature, and natural phenomenon. So again, recites and directed to are 2 different things because there are now 2 different questions. Recites is part of directed to. So that's kind of the first question. Is there anything in the claim that the examiner can point to and say, that's your abstract idea, that's your natural phenomenon? And of course, if the answer is no, the analysis is done and the claim is considered not directed to the judicial exception and is considered patent eligible. Now, if the examiner can actually identify something in the claim that relates or recites rather the judicial exception, there is now another hurdle, which is prong 2. Prong 2 asks whether the claim recites additional elements that integrate the judicial exception into a practical application. So this allows another path for applicants in the PTO to show patent eligibility, because they can say, okay, well, the examiner found something in our claim that they consider to be the judicial exception. Maybe we agree, maybe we don't agree, but the bottom line is there's more in our claim. Our claim also includes a practical application. And so if that practical application is found, that is again an indication of patent eligibility. Now, in practice, and especially in my practice, often the practical application inquiry of step 2A, prong 2 is relatively similar to the question in step 2B of whether the claim recites significantly more. If we sort of envision the prong 1 and prong 2 steps as part of step 2A, we'll see that even if the answer to prong 2 is no, that is, that the claim does not recite additional elements that integrate into a practical application, the examiner still has to answer step 2B, whether the claims recite significantly more. However, generally in my experience, those two questions tend to stand or fall together because, as we can see on the left-hand side, where there's a little box that says the inventive concept, and oftentimes the hook of the invention, the inventive part, whatever makes the invention novel and non-obvious, will also qualify as the practical application under prong 2 or the significantly more in step 2B, usually both. But in general, we wanted to go over these additional prongs that the PTO now requires its examiners to consider. In fact, the PTO provided even more guidance other than the actual questions in the prongs. The PTO has limited, as far as the step 2A prong 1 question of whether the abstract idea is recited in the claim. It's now limited those abstract ideas to 3 categories, which is the mathematical concepts, the methods of organizing human activity, and mental processes. And so this creates an even narrower opportunity for the examiner to find the judicial exception to be recited in the claim. The guidance does allow for some rare cases in which a judicial exception that does not fall into those 3 categories to still lead to an answer of yes in prong 1, meaning that the abstract idea is recited in the claim. However, the guidance requires the director of the technology center to approve such exceptions. So in general, they're supposed to be quite rare, and the examiners are generally limited to these 3 categories. As far as step 2A prong 2, which is the practical application question, the guidance also provides several categories that would qualify as the practical application. And that first one is the one that we saw in both McRow and in TechSec, improvements to functioning of the computer. This is listed first because it's often the one that is most useful to applicants. However, there's others. We see the application of the judicial exception using a particular machine or transformation of something into a different state or thing. Those 2 in combination are part of the now somewhat dead machine or transformation test, but can still be apparently can still be relied upon as part of the step 2A prong 2 analysis. However, just to reiterate, the improvement to the functioning of the computer really is the king, so to speak, of this this prong, this inquiry by the PTO. Okay, so the PTO also provides some limitations that would be found to be significantly more. So the significantly more question, if you recall, is part of step 2B of the 2-part step. And so as you'll notice, the first one there is also an improvement to a technology and technical field, and the second one is improvement to the functioning of the computer. So again, very similar types of claim limitations. And as I mentioned, oftentimes, if a claim limitation meets one of these 2 criteria, then that can be argued, at least at the PTO, under 2 different points, under step 2A prong 2 as part of the practical application, and then again argued under the significantly more step 2B question. Let's see here. So the other one of these limitations that I wanted to bring your attention to is the second one from the bottom. Adding a specific limitation other than what is well understood, routine, and conventional. So this brings us back to the Berkheimer decision that Marina was describing in the life science context. This is still very much relevant in the computer arts and can be used, Berkheimer can be, and the significantly more question can be used in the computer arts in the same exact way to essentially, the argument is not unlike a novelty or a non-obviousness argument. Essentially, applicant or the patent owner points to the part of the claim that really is the crux of the invention and says, look, this part is not well understood, routine, and conventional. So maybe this part also overcomes the prior art, but it also provides the significantly more to overcome any challenge under Section 101. So we've provided a lot of information, a lot of case law, and of course the PTO guidance. So let's distill it a little bit as to how we can apply all of this information in a way that helps us as applicants, practitioners, patent drafters, and prosecutors. Again, coming back to the claim is the name of the game. Those claims should be as specific and technical, and of course, include as many novel elements as possible. The difficulty arises if we recite a result rather than how that result is achieved. This was part of the problem in American Axle. Even though the invention was quite mechanical and quite physical, the majority there found that the claim recited dampening those vibrations, but didn't give enough detail as to how. And again, coming back to the lessons we learned from TechSec, for example, as much as possible, the invention should be geared as a technical solution to a technical problem. So the technical problem should be described in the disclosure, and then to sort of set up the stage, and then the claims will provide that technical solution. And okay, so then of course if the claim recites an element that is a specific technical improvement that is not found in the prior art, this again brings us back to the Berkheimer idea of if it's not found in the prior art, then it's likely significantly more than the abstract idea itself. And so there we can use that novelty as evidence of patent eligibility as well. Okay, just to kind of sum up, the bottom point there is to describe the invention with a high level of specificity, including specific components and how they interconnect and work together.
I would
Sure.
like to add one sentence. Also, it's important to remember that maybe the claims could include conventional or known steps. However, as Federal Circuit pointed in Illumina case which we discussed of 2020, that conventional technology can be used in unconventional way to provide patent eligibility. This is also important for patent eligibility analysis under U.S. law and at the USPTO.
Absolutely, yeah, that's a great point. Okay, so this is just to kind of sum up again, additional practice notes that we should keep in mind. The previous approaches and how the solution improves upon them should be described in the specification, and then of course there should be a clear link between that solution that's described as an improvement in the specification and what is cited in the claims. One reminder is to, if possible, demonstrate in the disclosure why any claimed elements cannot be performed by humans, either because it's not possible, not practical, or because humans would perform the function in a different way. So this is just a good thing to do in order to avoid that mental process category that the examiners are provided in determining the answer to question of step 2A, prong 1, since mental process was one of the 3 categories that they can find, a good way to avoid it is to make sure that whatever the process is that's being claimed cannot be performed in the mind. And so the final reminders that we want to make here is that the detailed disclosure, which is of course drafted when the patent application is drafted, and then any arguments that are made during prosecution should always keep in mind how any potential litigation might analyze the claims. So the detailed disclosure may not make too much of a difference to the patent office, but if a court is reading the entire patent application, we want to provide as much detail as possible to allow the court to find that there's an improvement to the functioning of a computer, or the invention provides some sort of technical solution to a technical problem. And likewise, while the examiners find the guidance to be binding, as Marina mentioned, the courts do not. So it is best, even when dealing with the patent office, to have an eye toward how claims might be analyzed post-grant. And so in order to do that, it's best to argue both based on the guidance, because that is what the examiners know and understand, but also based on the case law in order to set the stage to provide a foundation for any additional arguments that might have to be made later in a court that does not accept or is not bound by the guidance. So that wraps up our overview of Section 35 U.S.C. 101 as far as the life sciences and computer arts are concerned. I think there will be a survey sent around, and feel free to use that survey to ask us any questions or provide any feedback. Also, as you can see, our contact information is available. We welcome any follow-up discussion or questions that you might have. Marina, do you have anything to add?
Yeah, first of all, I would like to thank again all who joined us today. And if you have any questions or concerns, or maybe any future topics desirable for presentation or webinar, please contact us. We're always happy to answer your questions and consider your suggestions.
Okay, great. Thanks again, everyone, for your time and attention, and have a good day. Take care.
Thank you.